it conceptually. The only, and I support that bill conceptually. So just walk me through where you think the gap might exist and how this bill will, get rid of that gap.
Happy to do so.
Thank you.
So 42 U.S.C. 1983 is the Federal Civil Rights Act.
Right.
It provides that a state official can be sued in federal court for a violation of constitutional law.
Right.
Of constitutional rights. It does not include it does not include federal officials. And the reason it doesn't is historical, not for any conceptual reason. That creates a gap where there is no mechanism to hold federal officials accountable for violations of constitutional rights. This bill is designed to fill that gap. And as you read in the law review article, the professor believes was the original intent of the founders.
Yeah, I think he said, even in the law review article, that basically what he was arguing for is every state ought to have a 42 U.S.C. 1983, whatever that code
That's
section
correct.
is. And then we would have full parity and a full, truly, a government accountable to the people, not sovereign or federalism, but truly the people are the sovereigns, and executing a state level 40 U.S.C. 1983 on the state level would get us there. And that's what this bill is doing. That's it.
That's correct.
Very good. Thank you.
Yes, the sponsor, some questions about the amendment. So I'm reading the amendment. The key term is covered officer, and it says it means an officer who may make an arrest with or without a warrant for violations of the United States Code. Do Maryland officers of any stripe have the power, either with or without a warrant, to arrest someone for a violation of the United States Code?
We don't believe we don't believe so.
So this bill, as amended, would exclude all Maryland law enforcement officers, correct?
If it would include only those officers who are enforcing the United States Code.
And that would not include any Maryland law enforcement officer?
That is, in every circumstance that we can think of, that is correct.
Okay, that's my question. Thanks.
So, thank you, Mr. Chair. So this is, as Senator from the 42nd District stated, this is about, this will exclude, I guess, local law enforcement from any action, right?
That's correct.
And then my question is the part about make an arrest with or without a warrant for violations. So if you have a warrant, especially if it's a criminal warrant, regardless, hasn't that already been vetted by a judge? Wouldn't there be liability on the judge and not the officer for carrying out a warrant that's been handed to them?
The question isn't the behavior when carrying out the warrant. The point is simply that it is designed only to cover officers with police powers. And we're defining what that is as being able to make an arrest with or without a warrant here for violations of U.S. Code.
Okay.
For further discussion? Oh, so you're still going? All right.
Additional question.
No,
And
take your time.
It does not include a law enforcement officer acting under the authority of a joint task force that primarily enforces United States Code, including the U.S. Constitution and the laws of the United States. Did I read that right? So it does not include a law enforcement officer acting under the authority of a joint task force that primarily enforces United States Code. So if I read that, does that mean that if ICE is working in a joint task force with another allied law enforcement agency that they're excluded from this?
No, it's covered officers who are defined in Section 1101 of the Public Safety Article, working with the Joint Task Force. So it's only those officers defined under Section 1101.
And who are those?
That's the definition of Maryland law enforcement agents.
So this goes back again at covered officer does not include.
We are essentially excluding officers already covered under 1983.
So who are these officers then that would be a part of it? All federal agents?
So, yep, the hypo here is if there is a state officer that is, or a series of state officers who are working with a joint task force with a federal agency, because the state officers are already covered under current law, 42 U.S.C. 1983, that they are excluded from the, from this bill.
And, but the officers that are out doing the enforcement of a federal law are now, we're making them subject to recall by Maryland, by a Maryland court for potential violation of a, as this would have it, of a violation of constitutional rights for enforcing federal immigration laws.
This is not subject to recall. They would simply,
How do they get prosecuted then? You're saying they'd be prosecuted?
so this is not prosecuted. There's no criminal offenses here. This is civil liability only. No one will be prosecuted under the legislation in front of you.
That's even better. So you're making it a civil loophole to where anyone, even those that are deported, would have a civil right to go back and sue a federal agent in the state of Maryland exercising their responsibility for immigration within our own boundaries.
So I'd say the answer to that question is no. You'd have to have standing in order to do so. And it would not be in the exercise of their authority. If someone is violating a constitutional right, they are not acting in the exercise of their authority.
Their constitutional right. So I guess what I'm asking is, please give me an example then, because I'm trying, I believe this is linked to the immigration that has been tagged to many things this session, the immigration law and the enforcement of those laws, which again, 8 U.S.C. 1325 makes it a crime. And now we're opening up civil liability for the officers in the performance of their duty, these federal agents. Is that what you're saying?
So this is not aimed at ICE. So Professor Amar, the article that kind of burgeoned this whole idea.
Yeah, I don't care about his article. I'm just asking about fundamentally, how does this work?
Yep.
He's not practiced law one day. He hasn't practiced law in a court one day.
All right.
So what does the bill do? If we've crafted this bill out of his legislative law article, I want to know fundamentally, practically speaking, what does this bill provide for?
Hold on, before you respond, just real quick, just let's just get a break in time, like response, and if the vice chair is responding, let's just let him respond, and then we can go back and forth. But go ahead.
Sure.
Thought that's what I was doing.
Fundamentally, our officers that are Maryland law enforcement officers are subject to civil liability under 42 U.S.C. 1983. That's current law. We are creating a converse 1983 and providing that other law enforcement agencies are similarly subject to the same law that Maryland law enforcement officers are subject to, but instead of federal court, in Maryland court. That's the basis of the bill. No more, no less.
So again, my point is, this creates a civil remedy, if you will, for someone that feels that because the difference between criminal court and civil court is significant, preponderance of evidence versus proof beyond a reasonable doubt, So someone that feels within a state that has already significantly watered down the immigration enforcement responsibilities of our federal partners, that they could then seek civil remedies against that officer in the performance of their duties with or without a warrant. If they had a warrant, you would still, even if someone was deported, there's no limitations. Like someone could be deported and they could seek civil injunction or civil remedy on this as a part of that.
No, I think the thrust of this bill is to protect people from violations of their constitutional rights. And so under those circumstances that you described, unless there's a violation of someone's constitutional right, this bill is inapplicable and does not touch the scenario that you just outlined because there's no violation of constitutional right.
Well, and I appreciate that, but here's my problem, is that this state has passed legislation contrary to federal law because we know better. We know better. We don't want ICE in our streets. But we're inviting them by terminating a 287G program. So this is yet another slap at federal law enforcement in the performance of their duties, creating another opportunity for civil remedy to call them into court in the performance of their job, which is not exceeding their use of force, not doing any of these things, but these things are being challenged because nationally we don't like the optics of how things are being handled with our immigration customs enforcement officers.
So if they're operating within the scope of their normal duties, this does not apply. It's only for violations of constitutional rights. And take the absent the title of the bill, take this away from immigration only. No one, I think, would want any federal official, law enforcement officer,
Agreed.
to violate anyone's constitutional
Agreed.
right. And if that federal official did so, we would want to provide our constituents with an avenue to seek civil relief for that violation. And so,
Well, maybe I'm misguided in my impression by the title of the bill.
Understood.
So, thank you.
Senator Love.
Thank you, Mr. Chair. Thank you for that explanation, because that's where I was wondering. So, like, if an FBI agent were to come into my house and take documents out of my house without a warrant, without any probable cause, would that be the sort of, they've violated my house, Fourth Amendment search and seizure, would that be the type of thing that could fall under this legislation?
That's correct.
Thank you.
Senator James.
I wanted to help my dear friend, Senator from Frederick, just to sort of say, the worst case I can think of is Minnesota, where a couple of people were killed. And what people are worried about is if the federal government decides, which they have said, I hope they don't stick with this, but initially they said, we're not going to investigate ourselves, we didn't do anything wrong, and we have sovereign immunity. And so the people that are grieving the loss of those 2 lives, and I'm just using that as an example because it didn't happen in Maryland, and this is the kind of statute that would at least give people the right course of action to pursue a claim. They may not succeed. I'm not going to get into the merits of it, but I didn't realize myself, Senator, that there was this gap. And so you could be absolutely not violating the immigration laws at all, but while you were doing that, you happened to violate somebody's Fourth Amendment, the Fifth Amendment, or in the case of Minnesota, you may end up seriously injuring somebody in a way that, without a law like this at the state level, ordinary citizens may be quite lost and have no right forum. Doesn't mean they would succeed, but there just isn't a clear avenue. I share a lot of your concerns, but I think that what the professor wrote about so predates any of these issues. He brought this up in 1987, way before we had this issue. I'm surprised we didn't bring it up sooner, this gap in the law. But anyway, I hope that helped, and if I made it worse, I apologize.
No, you're fine, thank you.
Okay, so.
There's been a motion for a favorable, it's been seconded, it's open. Go ahead, Senator West, and then we're going to run.
Sorry.
Yeah.
I'm reading the text of the bill with the amendment interpolated. And I realized that under the original language of the bill, it said that an aggrieved party may bring an action against a covered officer who deprives the aggrieved party of a right, privilege, or immunity secured by the U.S. Constitution. And the U.S. Constitution's been deleted. And now it just says of a right secured under the law. Why was that change made? Because it does seem to me to be a significant change. The original bill only covered rights under the U.S. Constitution, and this bill deletes the U.S. Constitution and substitutes rights under the law. So what's going on?
I think you may be looking at a previous reprint.
Am I?
Under the reprint in our packet, on line 20 and 21 of the first page of the bill, it says law includes, and then it says the U.S. Constitution, and then underline and the law, and number 2, the laws of the United States. I have my reprint is dated 3/16/26 at 12:37 p.m.
I've got 3/26 at 12:38:55 p.m., a minute later. Do you have the reprint section? I'm looking up here. Yeah, it deletes U.S. Constitution. See what I'm saying?
No, you're on.
It's because the law is. Yes, sorry. That's referring back to the earlier definition. So when you say under the law, when the bill says under the law, what the law is a term of art that's defined previously in the bill to include the U.S. Constitution. That's
Oh,
in the
I see.
definition. Yep.
Okay.
No, good question. Thank you.
All right.
Good catch.
All right, thank you. And then I just want to confirm that 2 lines further down, it just says may seek damages. There's no limitation. Does that mean an unlimited amount of monetary damages?
Yet, my understanding is that damages here is confined by current law, meaning you couldn't get non-economic damages or
Right.
punitive damages, because those are only applied.
Damages under Maryland law.
Correct.
Okay, but in terms of, so it
would be economic damages.
oh, interesting. So if there were physical injury, you could recover your medical costs. And you could recover up to currently just under $1 million for pain and suffering. But you could not recover a larger amount of damages than that, is what you're saying?
That's correct. The bill neither contracts nor expands available damages under Maryland law.
Okay, and what about punitive damages?
There are no punitive damages in the bill.
I would have to specifically state punitive damages for them to be recoverable.
That's correct. That's my understanding.
Okay, thank you.
Again, there's been a motion, it's been seconded, and there's been discussion, so let's do a roll call. Oh, sorry, Senator McKay. Senator McKay.
Thank you, Mr. Chair. Senator, there was a Maryland shall issue had put in amending, asking it that a suit that can be brought to by an individual, state of Maryland, state agency, any county, city, municipality, or state of Maryland. Is that language in this whatsoever? Absolutely. That's okay. So Maryland shall issue, Mark Pennick had offered an amendment that said that the bill should thus be amended to provide that a suit may be brought against an individual, state of Maryland, its agencies, and any county, city, municipality of the state of Maryland. Is that such language in the bill as we're about to vote?
Not.
It is not. Was there any consideration for that?
So there is not, because my understanding is that someone with a civil suit under those circumstances already has the ability to sue their local jurisdiction, their local police, the state of Maryland. This is filling a very specific gap.
All right, well, he had mentioned Board of Education of Baltimore County versus Simmer Rubert, 409 MD 200 in 2009, that the General Assembly may waive sovereign immunity either directly or necessary implications. So does that address that, or?
So I appreciate what Maryland Shall Issue is saying. That's not the intent of our bill, so we left it out. I would certainly be willing to entertain further legislation if we came back, but that really has to do with state sovereign immunity. This has to do with constitutional law and filling the gap that 1983 creates. So we did not include that.
I mean, this organization and that particular gentleman is in this committee on a regular basis, good, bad, or indifferent. Don't you think we ought to consider that for this and not be
Yeah.
an additional bill?
So Mr. Panak is a constituent of mine. He is he votes in my election, and I appreciate the expertise that he provides. I don't disagree with what he's saying, just to be clear. I just think it's an entirely different subject matter, and don't think that this would be the appropriate vehicle for doing so. But
Okay. Thank you.
There we go. All right, so there's been a motion, it's been seconded. And for the record, I mean, those officers are going to be subject to liability under the State or Local Tort Claims Act based on the caps that we set. So, I mean, they're still exposed in that regard, but.
They all have caps, but federal officers.
Well, federal officers, there's a Federal Tort Claims Act as well, but I don't know what the caps are for the Federal Tort Claims Act.
Usually goes case by,
Yeah.
like claim by, statute by
Statute, just
statute.
said no.
Like, I don't think that there's like a universal federal cap on damages. It's depends on what type of suit you're talking about.
All right, Chris, go ahead.
So all of a sudden, we're talking about tort claims acts. Let me get the sponsor of the bill once again to answer two questions. Number one, would the Maryland Torts Claim Act, because Maryland law does, this is a bill under Maryland law, does the Maryland Tort Claims Act protect these people in terms of liability and other aspects?
It would not, no.
It would not. How about the Federal Tort Claims Act? Would that protect them in any respect?
I think that's an unclear issue of law that would litigate if someone were to be sued under this. I don't think we know the answer to that question.
Okay, so this bill could affect the national applicability of the Federal Tort Claims Act. Because if Maryland does this, presumably other states will try to do the same thing.
Yeah, other states are doing the same thing. It will unquestionably litigate.
Okay.
All right, roll call.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
No.
Senator Muse,
Yes.
Senator Folden,
No.
Senator James,
Yes.
Senator Henson,
Yes.
Senator Love,
Yes.
Senator McKay,
Nay.
Senator Charles,
Yes.
Do you have your-
Chairman Smith.
Yes. Senate Bill 346 passes 8-3 with the amendments. All right, we're now going to go on to Senate Bill 397.
Senate Bill 397 requires the Anne Arundel County Sheriff to appoint 3 majors at a salary to be determined by the Anne Arundel County Council.
It's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 397 passes unanimously. We're now going to move on to Senate Bill 67.
Senate Bill 67 extends from 5 years to 10 years the time after which a court is required to dismiss a charge for first-degree murder or first-degree rape against a defendant found incompetent to stand trial. The bill specifies that as part of the process of dismissing a charge against an IST defendant due to expiration of the statutory time limits, the court must provide the state's attorney and the victim who has filed a specified notification request, advance notice of the dismissal and an opportunity to be heard. And 2, at any time, the state may petition the court for extraordinary cause to extend the time of the charge. So it's not in your voting packet, but we did have an amendment from the bill sponsor. It would change provision of the bill to provide that at any time the state may petition the court for extraordinary cause, excuse me, to postpone the dismissal of the charge if doing so would not extend the defendant's confinement beyond the maximum sentence for the most serious offense charged. Would also strike a provision of the bill that provided for the court providing the state's attorney and victim or victim's representative advance notice of dismissal and an opportunity to be heard. Sure.
Okay.
Okay. We're now going to go into Senate Bill 12.
Senate Bill 12 requires a landlord of residential rental units in apartment buildings with 4 or more individual dwelling units to provide air conditioning from June 1st through September 30th each year as specified. Unless otherwise exempted under the bill, landlords are to provide air conditioning in residential rental units, 1, beginning June 1st, 2026 for newly constructed units, and 2, beginning October 1st, 2026 for existing units that undergo renovation that includes the replacement or substantial upgrade of electrical systems or heating systems. The bill applies prospectively only and does not have any effect on or application to any building construction or renovation for which the building permit is issued before the bill's effective date. The bill takes effect June 1st, 2026. There is an amendment in your packet. That's Amendment 663-425-1. The amendment increases from 4 or more to 10 or more the number of individual dwelling units in an apartment building to which the bill's protections apply. It deletes an exception in the bill for Housing Authority of Baltimore City developments built between 1940 and 1950 and row house public housing units acquired and rehabilitated by the Housing Authority of Baltimore City between 1960 and 1997. It adds a clarifying provision that the bill does not preclude a political subdivision from enacting more stringent air conditioning requirements.
We adopt the amendment. Let's do Senator McKay.
Just going to say, I want to thank the sponsor for working with me on this and look forward to moving the amendment.
there's one piece of the amendment that is actually, I think, is the inverse of what was intended. But the one part that you like, I think, is still there. So let's go ahead and adopt the amendment, and then we'll amend the bill as amended. Okay. So is everyone okay with adopting the amendment? Okay. All right. And now the bill is before you as amended. Senator West.
So I think the amendment deals with the two objections that were raised. Senator McKay had a concern with the number of units it would apply to. We've increased that now to 10 instead of 4. And with that, I think Senator McKay pronounces himself comfortable with the bill. There was also objections by some of the witnesses that we were giving Baltimore City a pass for 9 very old public housing structures constructed when I was a child. And that's now been taken out of the bill. It happened over in the House. We conformed this to what the House passed. And the House took it out, and apparently Baltimore City did not object. So I'm happy to take it out in the Senate as well. Now, the last section of the amendment, which I had no control over and wasn't aware of until recently, apparently the chair of the committee wants to revise this section, and I'm happy to do it. And just indicate what we're going to do.
So this section does not preempt a political subdivision that has enacted. So it does preempt. Okay. Insofar as it's less stringent or more stringent, or just full preemption? So the goal is to preempt jurisdictions from doing something. Okay. 80 degrees. Can't go low or high.
Okay? And they can't say it has to be 75. It has to be 80. That's
Gotcha.
the rule.
People should understand the uniform standard across the state.
Understood. I can get, that's an easy draft. I think we can adopt that in concept.
Yeah, we'll favor.
So you don't want local jurisdictions. 5.
Just because it's hard to be operating throughout the state and things patchwork. We're making a very significant leap forward in policy.
Hugely.
The least you could do for balance is to make sure that it's uniform if you operate across the state. That's all I'm saying.
And once this is adopted, all the landlords and the constructors of multifamily housing will be able to deal with it. They'll know exactly what the rule is. It has to be 80 degrees, no more.
So can you just give me clarity, because we've gone up and less than and more than, and then, so can you give me some clarity on what was said about the housing units in Baltimore?
Yes. So there are 9 very old public housing projects in Baltimore City that when I was a teenager were already in existence. And
So that's a long time ago.
yes, I'm saying
time ago.
I'm saying a long time ago.
1840, leave them alone.
Older than old.
One sentence here. When I was a freshman in college, I spent a week and a half sitting next to the city housing commissioner as a part of a winter study project from my college. And the big issues were about these public housing projects and the problems that they were having. And this was in 1969. So these things had been built well before 1969. They were not built with any air conditioning. And so they are apparently incredibly oppressive in the summer when we get these heat domes. And the city initially came against this bill last year and said we can't live with it unless you exempt those 9 projects. So we did the best we could. We excluded the 9 projects. In the House, for whatever reason, the 9 projects were put back in. The exclusionary language was taken out. The city did not object. It passed the House. So here it is in the Senate, and we're now conforming the Senate bill to what the House did, which is to take the exempting language out, which exempted those 9. Now, that doesn't mean the city has to put air conditioning in those projects now. Okay. What the bill says is if there's a substantial renovation of these projects, of the electrical systems or the furnace systems, if that happens, then they have to install air conditioning in the housing projects.
In all those homes, in
Well,
all those projects.
Independently, if the city decides to do a substantial renovation of project number 1,
Wow.
then they would have to put air conditioning project number 1, but not projects number 2 through 9, until they decide to do independently renovations of projects 2 through 9, at which case, whenever another project is attended to, they'll have to put air conditioning in that project as well.
So I just want to make sure I'm understanding this. So we have excluded these 9 projects. The preemption language does not put them back in, right? Unless they do a major renovation. So am I hearing this correctly, that the body wants to move forward with language that would exclude those living in the most oppressive, hot dwelling units that are government run, we want to exclude those, but we want to hold every private.
No, that's not right.
Okay.
Well,
Please
by
explain.
taking the language out completely that relates to the Baltimore City housing projects and striking it completely from the bill, they're simply under the same restrictions that all other existing housing projects in the state are that do not currently have air conditioning. So if there's a project in Frederick which doesn't have air conditioning, it has more than 10 units, the owner doesn't have to put air conditioning into that structure until the owner undertakes a major renovation of the electrical system or the furnace system in that particular structure, at which point the owner would have to put air conditioning into that structure. So those 9 projects in Baltimore City will be treated exactly the same way as housing projects in any other place in the state.
So the 9 housing projects are not going to have to put air conditioning in their building.
Unless there's a
Just
substantial
saying, like,
renovation.
the whole idea was to put, the whole idea was originally that we want to have, in these very hot times, we want to have air conditioning, and we want to require these landlords to have air conditioning in these units. And originally, your bill was 4 units.
No. Well, no, it was 4 units, now it's going to be 10 units.
Right, that's what I said
That's not what
originally.
we're talking about here. The bill all along did not want to subject landlords owning projects which don't currently have adequate air conditioning, did not want to subject them the day the bill takes effect, was it later this year? Did not want to require them immediately to install air conditioning in their buildings. They only have to do that when the buildings undergo a substantial renovation, at which point, along with whatever else the landlord is doing, the landlord will have to install air conditioning in the buildings.
So that's what I'm saying. So we have excluded these 9 government.
They're being treated the same as everyone else.
They're being treated the same as every other building all across the state of Maryland. They're not being mentioned in the bill at all.
Well, they're being treated the same.
If there's a do it again. If there's a building in Montgomery County that was built 10 years ago and has no air conditioning that cools the building down to 80 degrees, under this bill, the landlord of that building will not have to do anything with respect to his building until the landlord undertakes a substantial renovation of the electrical system or the furnace system of the building, at which point the landlord will have to bring the building into compliance with this bill, namely to upgrade or install air conditioning so that it's no hotter than 80 degrees on the hottest summer day. Got it?
Okay, thank you.
I understand what you're saying.
I just want a clarification from Senator West. So Senator West, this could be accomplished by window units or central air, right? Because I'm assuming the trigger for substantially upgrading a building's electrical was, you were thinking about, well, if they're going in to do that or replacing heating, that's the time they would do an HVAC as opposed to doing, not that you're saying they have to do it, but that's what you're thinking, was that would be the wise time to do an HVAC if you want to do a central. But you're not choosing between a window unit, an individual unit, or central air, even though you're talking about replacements and upgrades of electrical systems, substantial, triggering.
You're right.
Okay, I just want to make sure
The bill
that's
does
good.
not say
More
you've got to
flexible.
do one kind of air conditioning as opposed to another.
More flexible. Okay, thank you.
All right, so we've adopted the amendment, and then we've amended it for the preemption language. Senator, yeah, sorry, Shamari, go ahead.
So is
Senator
this,
Taylor.
is this going to supersede jurisdictions that may have something already like 75 or 85 in place? Is the intent to supersede? Understood. Okay.
All right. All right, there's a motion for a favorable with the amendments.
We gotta adopt this amendment first.
We did.
Okay.
Everyone did? Sure. Yeah. Yeah. All right, is everyone okay being recorded in the affirmative? All right. Senate. All right, Senator Fulton is down. Senate Bill 12 with the amendments passes 10-1. All right, we're going to go to Senate Bill 250. Actually, you know what? Let's go, hold on, since. Senate Bill 939.
Senate Bill 939 specifies that the exemption for owner-occupied residential real property in bankruptcy proceedings includes residential real property of a settlor held in a revocable trust. The bill also increases the exemption amount for residential real property to $300,000 for an individual who is at least 60 years of age and is a veteran or has a disability as specified, and to $150,000 for any other individual. If multiple individuals in the same bankruptcy proceeding claim the exemption for the same property, the total exemption may not exceed $300,000. Beginning in fiscal year 2028, the exemption amounts are adjusted annually based on changes in the consumer price index and rounded to the nearest $25. The bill repeals existing provisions prohibiting repeat claims for an exemption of the same owner-occupied residential real property. The bill applies prospectively to bankruptcy proceedings filed on or after June 1st, 2026. In the amendment, there's an amendment, that's Amendment 313424/1. It's in your packet. So amendment number 1 is technical. And amendment number 2 essentially just moves the provisions of the bill to a different subsection. This is instead placed under subsection F as opposed to it moves it to subsection B as opposed to subsection F. Substantively, it still remains the same.
All right, the amendment's been moved, it's been seconded. Is everyone okay adopting the amendment? Excellent, okay.
That's the only amendment that I had for this bill.
The amendment that he just moves the personal property section. So what the purpose of the bill is preserving people's equity that they have in their home. When a person has a bankruptcy, if the equity does not exceed the amount that they are claiming, then it can force the sale of the home so that it can pay off the debts. But if they have equity that they can claim, then they can hold on to the home if the equity exceeds the amount of the claims. So what this does, it gives them the exemption. When you raise it, you can keep the equity that's in the property that you already have. So by raising that exemption, you're giving them more opportunities to hold on to their property that they've paid for over time and keep the equity that's in it. What Shamari was talking about in the amendment is there's some personal property language that's in there as well. Not talking about the home, but talking about your apparel and some other things like that, that he's moving to a different section because it doesn't have to do with your real property, it's personal property. Did I get that right, Shamari? Like, but didn't tell me.
She nailed it.
Yes, that's correct.
Thank
Sorry.
you.
But then when was the last time that this adjustment was even looked at was like in the 80s or something? How long ago? It's been a long time, right?
I think it was the 80s.
It's currently sitting at $38,000. When you think about how much a person's home is worth and how much equity a person has in their home, with property values having gone up drastically since the 80s, if you're only able to hold on to $38,000 of the equity in your home, you're not going to be able to claim much of that in a bankruptcy proceeding. So this gives people the opportunity to cling on to just a little bit more of that so that hopefully they can have some of the equity in their home in a bankruptcy.
Thank you, Mr. Chair. So the amount that is kept from being taken from the debtor, $150,000 for an individual or $300,000 for an individual who is at least 60 years old and is a veteran. Am I reading that right? Or has a disability? I'm just wondering why the different numbers for the different people.
That was how the bill came in. I guess that's just how the policy call on the sponsor's part.
Yes, so it is a either, so it's not that you have to be both. It is for individuals that are over the age of 60, understanding that for folks that are over the age of 60, their opportunity to earn additional income to be able to add to their wealth is, those years are gone. So their home is probably their biggest asset. They're gonna have to be able to perhaps borrow against that home if it comes time to pay for medical bills and debt, when it comes time to pay for long-term care and other things of that nature. So if they find themselves in a bankruptcy and you're over 60 and you're going through bankruptcy, presumably you might have a lot of equity in your home because you probably purchased it sooner, you probably paid for it for a very long time. So if we're talking about the amount that they could be able to claim exemption on, we want them to have just a little bit more so that they have that to be able to carry them through for a longer amount of time, since presumably they wouldn't still have the opportunity to then restructure after a bankruptcy.
Okay, so this says at least 60 and is a veteran or has a disability. So it's not for everyone who's over 60, it's just those two?
Okay, sure.
Okay.
Thank you.
It just, okay, thanks.
So I'm looking at the fiscal note, and it says individual that is at least age 60 and is either a veteran. So yes, we could do, I think the exemption for veterans, certainly there is a policy argument to be made why that is important and a group that we certainly want to support. But I think that the narrowing of that to veterans over 60 when we're doubling it, and then people with a disability, I'm fine with leaving it narrow in that way as well, because we do still have the, we do still increase it significantly for everybody. So I'm fine with leaving it as drafted.
I was almost saying, like, I know 60, I think the 60-year-old argument is very compelling. The veteran, look, I'm a veteran, so I get it, but, like, I'm not sure that's as germane to the age thing. So, I mean, I was thinking, maybe I don't know if you were saying this, Senator Love, but 60-year-old, I mean, I get that. And so if you want to I don't know if you want to leave the veteran thing in or not, but I think you shouldn't have to be a 60-year-old veteran to get it. I think 60-year-old is a compelling argument. And
that's for the higher tier, Mr. Chair.
Yeah. Okay,
You could tap into the greater amount, but for any individual, it would give them the amount that's in the bill. That's right.
Yeah. Senator McKay.
Have we weighed in with this amendment for the Veterans Caucus or anything like that? I mean, that would make sense to understand where they are
long as you're 60.
Sure.
I don't think you have to use.
60 and then scrap
But before we do that, we probably ought to make sure that that's,
Because if
I mean, I don't want to go to the floor and then try to fix it, or go over to the house and try to fix it.
60,
If there's going to be an issue.
as long as you're 60, you still apply. You know what I mean?
Right.
So, you shouldn't have to be a 60-year-old veteran only to get this. It's not going to hurt the veterans. Because if you're a veteran,
If you're a veteran under 60, you don't get it.
you don't get it anyway, but if you're 60 and you're a veteran, you're still going to get it, the benefit. It's not going to hurt them. It won't change
I'd like
their
to get
eligibility.
some kind of clarification.
What's your concern?
Don't know how the veterans are going to, I mean, I hear what the chair is saying, yes, I'm taking into consideration, but, anyhow, okay. I'm just not prepared to move forward with it until
Okay.
we answer that, but that's okay.
It will not hurt veterans, though, if we change that, if you take it out, because as long as you're 60, you could, and you're a veteran, you still qualify, or if you're 60, you're not a veteran, you're going to qualify, so. Senator Muse and then Senator West.
Just clarification. So if I'm 60, that applies to me. If I'm 60 and I'm not a veteran, that will apply to me. If I'm 60 and a veteran, it will apply to me. So there's no real difference in the application of this. Is that correct?
Under the chairman's amendment.
Right.
That would be correct under the chairman's amendment. As currently drafted, you would have to be 60 and a veteran for the additional exemption to apply to you. So for the chairman.
I'm glad you're my cousin. You are. Yeah.
I got you.
Okay, I'm good.
Senator West.
I see Mr. Enton is out in the audience. He and I both did the same kind of work when we were practicing lawyers. We both represented credit lending institutions. And I'm sure he would agree with me that there is a collateral consequence to this bill. Credit will be less easy to obtain, so long as the person's home is exempt up to the tune of $100,000 or perhaps $300,000. The person who wants to borrow the money will have a harder time borrowing money because the collateral, which might otherwise be available, won't be available. In those situations. So I think I'm going to vote for the bill because I like the policy, but I think when we vote for this bill, we should know that the collateral consequence will be credit will be less easily available for people after this bill passes.
I'm glad that you asked that question at the bill hearing when the experts were here and they were able to explain that the lien that's against the property is a priority lien and that it would be satisfied before these exemptions are applied so that the not the title company, but the lender would be made whole. So they were able to answer that question for you at the bill hearing.
Right. No question the lien would not be fair. But in many cases, lenders don't take the lien. They just rely on the fact that there's so much equity in the property without taking a mortgage or deed of trust against the property. And if this bill goes through, then there will be less equity available in the property. And as I say, the credit will be less freely available.
I disagree.
Especially since the numbers haven't been adjusted. I mean, since for 40 years, I mean, that just, I don't know. I don't agree that that's going to freeze access to capital in that regard, but go ahead.
So if in, whatever, 40 years ago, it was how much, 38,000? So it should be a pretty quick and easy fix. I mean, we're going 8 times that, or however many times, 6 times that. What's the CPI from the past 40 years of what was at the time deemed a reasonable amount of 38,000? What would that put that number at? It wouldn't be 300,000. I mean, yeah, sure, that's why I'm asking.
Yeah.
Is this was attached to? 6.
Why wouldn't the body, or if we're looking to do that, why wouldn't we look to do it under that founded guidance of the original legislative intent from all those years ago to be consistent instead of basically taking all of that and then doubling it? And that's fair, that's fair. I'm just saying, so we had a number, it hasn't been looked at. If we take it according to what the increases have been, it gets us at about 140 couple or somewhere in that range, 150. Why wouldn't we take the number of 150, which then would also address some of Senator West's concerns about the equity and the people being able to get a loan or have equity, use the equity from their home?
For everybody under 60. It's 150 for individuals. The 300,000 was for the additional for people that qualified that were 60 years of age and a veteran, or 60 years of age and disabled under the bill. Those were the only ones that could get the $300,000 exemption. Everybody else was
Okay.
just 150.
So that must be what I missed then. So did we drop the veteran part?
So under the chair's proposed amendment, what we would do is just have everyone 60 and over, just have it be a senior benefit. So they wouldn't have to be additionally qualified as veteran or as disabled, just a senior benefit.
Yeah, but I just, we're broadening it though. Like we had reasons, like if you were disabled or if you had a veteran status with disability, or you had you were older and had a disability, that was a justification for the higher, insulary number. But to just do it on an arbitrary number of 60, I don't
you think 60?
I don't agree with that.
I think 60 might not.
I am a veteran. I'm like, in this sense, it's not you have to be a disabled veteran. It's just a veteran. And so
Yeah,
for me,
I know that, but that was a courtesy.
I mean, look, we're both. I mean, like,
Yeah,
but
I get it.
Just, and I want to help veterans. I get it. But it just by virtue of just simply being a veteran, it didn't. It's the extra qualifier doesn't make sense here because several
Well,
veterans.
the one was veteran and one was disabled,
Yeah,
right?
yeah.
I think under the chair's amendment, he gets to help all veterans because as it's currently drafted, it only would apply to 60-year-old veterans or veterans that have, 60-year-old plus veteran or 60-year-old plus disability. So if you drop the qualifier of the veteran status or disability, then you would have to just be 60 years or over to get the $300,000 exemption.
that's-
So it's a senior benefit instead of the qualifiers.
But that's what I'm saying. That's not I don't, like taking that veteran away but the disability part, I totally get, right? You're 60, you're disabled, regardless, that's fine. But if we're looking, now we're just adding an arbitrary number to say 60, and you get an extra, 300, you get an extra $150,000 on top. Like, I just don't agree with that part of it. Like, I think we should be, unless there was something like and that's just for me. Like, I mean, that's where I'm at on that. If you're gonna take veteran out, take it out, but you're taking people, now you're just making it for everybody, where the intent before, if I'm understanding correctly, was those that are disabled. And then there was also a caveat or, an appreciation measure, or whatever you want to call it, for veterans to be included in that also. But they were separate and parcel apart. You didn't have to be a disabled veteran. It was if you were disabled, period, over 60. Is that correct?
60 plus veteran or 60 plus disabled.
Disabled, right. But I'm saying they were separate. They didn't have, they were
Correct.
two separate.
That's right. The
Veterans,
veteran
yeah.
did not have to be disabled.
Correct.
Correct.
Okay. Thank you.
All right, so we moved the First Amendment, the Second Amendment moving veteran. You moved that.
So the First Amendment was to just make it 60 with nothing?
No, the First Amendment was the interlineated copy that's before you. That was the First Amendment.
With the personal
one's already
property.
adopted.
Yeah, we adopted
Gotcha.
that. So the Second Amendment is just moving,
So the Second Amendment
removing veteran,
on page 3,
yeah, is a veteran,
Run in.
yeah. There's no line, but.
2A and B, you're gonna strike A and B.
Yes,
And the and in number 2.
yes. Is everyone okay adopting that? Okay, now those before you, Senator McKay has a comment question.
Okay, so veteran out. That's fine. That answers that question. So my question is, so how does this affect rural communities? So in Allegheny County, anybody can answer this question. So the average home value is $145,000. And the median household income is $41,000. I understand that the maker of the maker of the bill disagrees that it's going to cut down on the amount of credit or availability that somebody's going to have. How does this affect those counties that are not wealthy? And is there a way to cut them out?
So it would be, they're preserving the equity that they have in the home. So the home is still subject to the mortgage lien, and the lien is a priority lien. So the lender can still collect on the lien, and they would only be able to exempt what they have in equity up to what they have in equity. So if it did not reach the cap of what they can claim, then they couldn't just claim it arbitrarily because there is a $150,000 exemption. They would still have to have up to what they could claim in the equity on their property. So let's say their total value of their property was only $100,000. They couldn't claim a $150,000 exemption. Let's say their total value of their property was $100,000 and they had $20,000 in equity, then they could only claim what they held in equity in the property. Let's say the rest of the note on the property was for $80,000. Then their lender would still be able to, if they were in a bankruptcy proceeding and they had their priority lien that they were enforcing, they could still enforce their lien because it's a priority lien.
Senator West, would you agree with that, or?
Well, there are lots of different hypotheticals you could raise. I guess the one I would, if you got a house in Allegheny County and the value is $100,000, I think that's the hypothetical we're talking about here, and there's a mortgage against the house right now, the equity would be less than $100,000. So under this, if a lender were to make a loan not secured by a mortgage, then the lender would not rely on any equity in the property because all the equity would be exempt from a collection proceeding or from in a bankruptcy situation. So it would force the lender, if he wanted to lend against the equity in the property, to take a mortgage or a deed of trust, a second deed of trust, or second mortgage to capture that remaining equity. It would be a more expensive transaction. If you wanted just a straight loan, you probably wouldn't get it. The only way you'd get it is if you granted a second mortgage or a second deed of trust on the property. Senator Henson, do you agree?
I agree that a mortgage lender would make a mortgage and that the home would not be collateral in a mortgage loan? No.
No. The person comes in and wants to borrow $25,000. Under normal circumstances, the lender might be willing to make an unsecured loan for $25,000. But because there is no equity that would be capturable in this situation because of the exemption, the lender would probably not be willing to make a $25,000 unsecured loan. The lender might be willing to make a $25,000 secured loan, secured by a deed of trust, second deed of trust, on the equity in the property, but would not be willing, my guess, it all depends on the lender's underwriting standards, but it would be likely, I think, that the lender would refuse to make an unsecured $25,000 loan, knowing that there's no recoverable equity at all in the house of the borrower.
I think that what the bill is contemplating is the first loan. I think the bill is contemplating people's deed of trust that secures the note to the property. I do get what you're saying in terms of if you want to take out a personal loan and you want to use your home as collateral to secure a personal loan. But what the bill is contemplating is the bankruptcy proceeding where you're trying to save your home as the personal residence.
Senator James.
probably Senator Henson can help me. If we go to 60 and over, are you thinking about the fact that at that age, more, even though people are living longer, more people than not are retired, nearing retirement, and then there is the profound age discrimination. I'm really worried about the last place we're not protecting all these middle managers that are losing jobs, and they're in that age bracket of, let's say, late 40s, early 50s, all the way up to like mid 60s. They can't find jobs. So, but anyway, was that your goal? I know you added disability and veteran status, and we've removed them, but I'm thinking the bifurcation does have logic, whether it has a veteran or not, whether you're disabled or not, because regardless of those two, you're at 60, where I think people are experiencing a lot of age discrimination and a winding down of their most profitable years. Now they're facing a bankruptcy. Is that the thinking?
That's correct.
Thank you, all right. I just wanted to make sure about that. This line extends.
Yes. Okay. Makes sense.
Adult under 11307 of the corporations article provides for reporting financial exploitation of adults, and those adults are eligible at age 65.
Let's raise the age of 65. It's my amendment. I'll put it out. Is everyone okay adopting that? Okay. At least it's congruent. All right. Everyone's okay adopting the amendment. All right. Now the bill is before you as amended. There's been a motion for a favorable. There's a second. Do we need a roll call? Roll call.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
Yes. Yes.
Senator James,
Yes.
Senator Henson,
Yes.
Senator Love,
Yes.
Senator McKay,
You took out the veterans, so I guess yes.
Senator Charles,
Yes.
Chairman Smith.
Yes.
Passes unanimous.
We're going to go to Senate Bill 320.
Senate Bill 320 expands eligibility for an expungement under 10-110 of the Criminal Procedure Article to include a charge that was not disposed of by unequivocal conviction, but was instead disposed of with a no finding designation, or included a case that was designated by the court as having been terminated without finding. There is one amendment in your voting packet. Or it may have actually been handed out separately.
Yeah, it's on
That is Amendment SB 320, 643-229. This was language that over the summer the judiciary had come up with it would strike provisions of the bill and provide that an expungement-eligible offense would be an offense listed in items 1, 2, or 3, where a remaining charge was either disposed of by a court with no finding designation or included in a case that was designated by a court as having been terminated without finding.
Adopt the amendment. Can we adopt, this is the language that, and we had this bill last year, Senator Muse, and then we worked over the interim. Oh, wow. Well, I know we worked with the judiciary over the interim, and so I know there's the consensus language, so. Move the amendment, it's been seconded, it's okay. Now the bill's before you as amended, motions for a favorable. It's been seconded, Senator Folden has a question.
So I just want to, I'm reading from the State's Attorneys Association on this. Did we get?
Yeah, John Cox had a different language. At one point, I had tried working with that language and just could not seem to make it work with the statute. But the language in the amendment that's handed out came from the courts and seemed to be language that they were comfortable with. And
it came from the judiciary
issue. It did.
Okay. All right. Thank you.
Exact same posture it was in 2025? No. How much difference?
Well, so as introduced, yes, it's in the same posture as it was introduced in 2025.
But with the amendment?
With the amendment, the amendment is language that the state judiciary had proposed in lieu of the language that was introduced in 2025.
Okay. The sponsor of the bill? Yes. Yes. Okay. So I'm just surprised we didn't work on this like during the interim or anything like that. We did. We did, but even though it wasn't introduced, it didn't get introduced with the interim. Okay.
There's been a motion for a favorable, it's been seconded with the amendment. Is everyone okay being recorded in the affirmative, or do we need a roll call? Everyone's okay being recorded in the affirmative. Okay. So Senate Bill 320 with the amendments passes unanimously. Senate Bill 631.
Senate Bill 631 alters various provisions of the Corporations and Associations Article, including those regarding the date of acceptance of a charter document for record by SDAT, when the document is rejected and then later resubmitted, actions taken pursuant to a final order in a bankruptcy proceeding, fines imposed on foreign corporations not qualified or registered to do business in the state, and limited partnership agreements.
This is the annual business law sections cleanup of the corporate law bill. It had 5 different provisions, none of them terribly substantive. They all clean up problems with the existing law. There's no opposition. I don't recall there being any questions.
I just have one question.
What's the question?
Have you consulted the proper section of the MSBA and Mr. Carlson had
Yeah.
to review this bill?
Yes.
All right.
Yes.
All right.
Absolutely.
Thank you very much.
For the
Senator.
last time, I'll never do that again.
All right.
You get these next year.
Until I pass it off.
All right, so there's a motion for a favorable. Second, is everyone okay being recorded in the affirmative? All right. Senate Bill 631 passes unanimously. All right, let's do Senate Bill 514.
Senate Bill 514 establishes the offense of misdemeanor assault in the third degree. The bill specifies that the district court has exclusive original jurisdiction over third-degree assault cases and specifies that a person convicted of assault in the third degree is subject to imprisonment for up to 90 days and/or a maximum fine of $500. It also authorizes the expungement of a conviction for assault in the third degree. There is a amendment in your voting packet. Is Amendment SB 514-393-020. Let's see, in the reprint of the bill, this would amend a provision of the courts article and provide that a district court commissioner may not issue an arrest warrant if the application for a statement of charges alleges the commission of only assault in the third degree.
Senator, we'll come back for the commissioner stuff later as a full review stuff, but yeah.
We're starting to chip, I like it.
We're starting a little.
Camel's nose.
It would revise the definition of offensive contact to, instead of being a domestically related crime, instead it would be an act committed against a person eligible for relief for a protective order. And it would also have a provision that would go on, be in addition to existing bill language. Existing bill language provides that unless specifically charged by the state, assault in the third degree is not a lesser included crime of any other crime, and assault in the third degree is a lesser included crime of second degree assault if specifically charged by the state. And that is the amendment. The latter amendment,
Assault in the third degree and assault in the second degree.
right?
What are these differences?
So if you think of assault in the second degree as being any assault short of a first degree assault, which would be something that causes life-threatening injury or serious bodily injury, or is committed with a firearm, or involves strangulation. Second degree assault is basically every other type of assault, which could range from a really bad physical injury all the way down to offensive conduct or frightening. So third degree separates if you think of assault as being harmful or offensive conduct, third-degree assault places a divide between those and places harmful conduct in second degree and offensive conduct in third degree. So if something is a physical conduct or contact, but is not harmful, it would be a third-degree assault. Yeah, there's actually a. There's actually, so under existing law, if you frighten somebody by causing them to apprehend that you're about to commit a battery against them, and you have the apparent ability to actually commit the battery, then that is a modality of second-degree assault.
I'm not frightening somebody that might have
No.
We're criminalizing.
So we're going to adopt the amendment, and then now the bill's before you as amended. Further discussion.
Thank you. And Jamie, I think you were in the explanation to Senator West explaining the two amendments and how they work with the not included is included as a lesser included offense. I think one of my concerns initially was making sure that we fleshed out putting a wall between second-degree assault and third-degree assault, making sure that we didn't leave the overlap there. Do those amendments help us with that?
So I guess let me backtrack that a little bit. As far as third-degree assault, it would not include conduct that is harmful. And I direct you to the definition of offensive contact, which is non-consensual physical contact that a reasonable person would find to be offensive. There are certain exclusions from that. But second-degree assault would still include harmful or offensive contact. And I know we had discussed the idea of putting a hard wall between those. And that's where you see the lesser included language on the following page come in. So you could actually charge third-degree assault as a lesser included of second-degree assault. And it would, second-degree assault would include offensive contact.
That,
The third degree would merge, right, and the third degree would merge into, if you charged both, the third degree would merge into the second degree. Because by proving both of them, by proving second degree, you would proven third, by proving third, you would also prove second.
and so if you charge both and you prove the elements of both and a person was sentenced, would the court have the choice of sentencing them to up to 10 years under the second degree or just 90 days under the third degree? Like, how do you get between one or the
It would
other?
be, so the ceiling on it would be the 10 years if they were charged and convicted of both,
Okay.
yeah.
Are there any other ways we can make sure we are getting good outcomes and that we are not? And Chair, I know that it was a great deal of work put into it by the work group to make sure that we had the option for a third degree because we didn't want people to automatically just have 10 years and nothing else if they had more of the offensive contact, but it wasn't harmful. That the whole goal of the bill is to create that other option so that there is a third option there so that people don't have 10 years hanging over their head. But is there a way to draw a wall between the second and the third degree so that it's not discretionary if you're charged with one or the other? Or do you feel like the amendments that we have in the bill get us there, or?
Yeah, I think the amendments get us there because I talked to a prosecutor afterwards, and invariably they're going to charge both. And I think because third merges with second, if it's that serious, if it's determined to be that serious, then it's going to, I don't think we've done anything detrimental there, but by allowing for an escape valve for the third degree, if the facts of the case don't kick it up to the conduct that would be of a second degree nature, I think that's a good option. I mean, but I'm under no delusion that they will charge both. I mean, I understand that. But so the answer is yes.
Okay.
I was thinking about that all weekend. Yeah, I just, you don't want third-degree nature conduct drifting into the 10-year realm. I understand what you're saying, but I think it's as close as we can get. I had the same concerns. I was thinking about it.
When I tried to look up parallels to figure out when there was discretion in areas of overlap, is this happening in a non-disparate way? And the only kind of other parallel I could find is when there's areas where the law has overlap between things that have mandatory minimums and laws that don't. And in areas where there are mandatory minimums, I think it was the Maryland State Commission on Criminal Sentencing Policy, their report indicated that in those instances that there was racially disparate outcomes for people, and people were charged more with the mandatory minimums, Black and brown people. And so I know that with this statute, I just would want us to commit to coming back and just looking at the data to see if it was something that was happening there. If I can put in a plug for another bill, I know that Senator Sidnor has a bill that would look at our criminal code more uniformly, to take a look at the way that we were sentencing and the way that, laws were impacting different people. I know it's a priority of the Legislative Black Caucus, but that sort of work, I think, is something that we would need to commit to more holistically to kind of understand how these things fit together, particularly when we're adopting new areas of the code. But I do appreciate the great deal of work that has gone into this bill.
I couldn't agree with you more wholeheartedly. I talked to Senator Sidnor about his bill, and we're going to be working on that. We're going to be voting every day this week. Everything crosses over by Monday. We've got some time to kind of to flesh some things out. There are a lot of things that are not on this list that are still being worked on, so that's certainly a priority of mine as well. No. That bill's just not on there. No. So the bill is before you as amended. Motions for favorable. Thank you, Senator Henson, just for the discussion. It's very important. Especially when you're venturing into new areas of law, it's very important. Since seconded, do we need a roll call, or is everyone okay being recorded in the affirmative? All right. So Senate Bill 514 with the amendments passes unanimously. So enjoy this one, Senate Bill 626.
Senate Bill 626 repeals the requirement that a licensed healthcare practitioner determine that an individual's sex designation should be changed for the purposes of issuing a new birth certificate. Instead, an individual would have to make a written request under penalty of perjury to the Department of Health for a new birth certificate with a sex designation that differs from their original birth certificate. When issuing a new birth certificate, the Secretary of Health must allow an individual to designate the sex of the individual as female, male, or unspecified or another. If the individual indicates unspecified or another, the Secretary must ensure that the new birth certificate displays an X in the location that indicates the individual's sex. The bill also alters provisions regarding issuing a new birth certificate due to a name change of a parent who's listed on the birth certificate. Finance we are secondary on this. Finance has already voted it out.
So we're secondary on this. I'm going to hold this today, but I want people to just, no. Yeah, I'm not. Finance voted yes. That's why we have it. We're secondary on this. That's why we didn't have a hearing, because we're secondary. I don't know. I don't think you did.
We haven't been able to send anyone to joint hearings because of the attendance.
Well, I just figured that's where Nick was all of a sudden.
Oh, that was solid. Oh my God.
I told y'all, man, 10 minutes left.
All right, so we're gonna listen, everyone. Maybe. All right. Everyone is, understand that we're secondary. We've got to move this one out. So just take a look at the bill. We'll ask more questions. We can
I'll go back
understand
and
it.
watch the hearing if you so desire.
And we're gonna close out voting on that note. And we'll, I'm sure you will have a lot, I'm sure a lot of questions will be asked. All right. Have a good evening, everyone. We'll see you tomorrow.